Welcome to our discussion on interest group strategies. Interest groups use two kinds of strategies to advance their causes. Direct strategies involve actual contact between representatives of the interest group and policymakers. Indirect strategies use intermediaries to advocate for a cause or generally to attempt to persuade the public, including policymakers, to embrace the group's position. Direct strategies to advance interest groups. Groups often opt for direct strategies when they seek to secure passage or defeat of a specific piece of legislation. These strategies include lobbying, entering into litigation to change a law, and providing information or expert testimony to decision makers. Interest groups hire professionals to lobby or communicate directly with policymakers on the interest group's behalf. President Ulysses S. Grant coined the term lobbyist when he walked through the lobby of the Willard Hotel in Washington, D.C., and commented on the presence of lobbyists waiting to speak to members of Congress. Today, lobbying is among the most common strategy that interest groups use, and the practice may include scheduled face-to-face meetings, buttonholing members of Congress as they walk through the Capitol, telephone calls, and receptions at special events hosted by the interest groups. The professional lobbyists whom interest groups hire are almost always lawyers, and their job is to cultivate ongoing relationships with members of Congress and their staff who have influence in a special policy area. In many situations, lobbyists help navigate access to these policymakers for industry and interest group members. Interest groups have learned that one of the most effective ways of influencing government is to hire former government officials, including cabinet officials, members of Congress, and congressional staffers as lobbyists. That's the revolving door. Because these ex-officials often enjoy good relationships with their former colleagues and have an intimate knowledge of the policy-making process, they are particularly effective in influencing government. Frequently, this practice creates an issue network, the fluid web of connections among those concerned about a policy and those who create and administer the policy. Similarly, an interest group's efficacy often depends on its having close relationships with the policymakers involved in decisions related to the group's causes. During the rough and tumble policymaking process, the interaction of mutual interests among a trio comprising 1. Members of Congress, 2. Executive departments and agencies such as the Department of Agriculture or the Federal Emergency Management Agency, and 3. Organized interest groups is often referred to as an iron triangle, with each of the 3 players being on one side of the triangle. Although each side in an iron triangle is expected to fight on behalf of its own interests, constituents, or governmental department, the triangle often seeks a policy outcome that benefits all parts of the triangle. Often this outcome occurs because of close personal and professional relationships that develop as a result of the interactions among the sides in an issue-based triangle. And sometimes the individual players in a triangle that is focused on a particular issue, say military, police, or subsidies for tobacco growers, share a personal history, have attended the same schools, come from the same region of the country, and have even worked together at one time. Such long-term relationships can make it difficult for opposing interests to penetrate the triangle. Sometimes interest groups challenge a policy in the courts. For example, the 2010 U.S. Supreme Court case that resulted in a drastically altered political landscape for campaign funding came as the result of a lawsuit filed by an interest group. In Citizens United versus the FEC, or Federal Election Commission, the interest group Citizens United argued that federal bans on corporate and union expenditures to promote or target candidates for federal office violated the organization's right to free speech. A 5-4 majority of Supreme Court justices agreed with the interest group and lifted the ban. In other instances, interest groups sue to prevent a particular public policy from being enacted or to prompt a court ruling on the constitutionality of an issue. The latter was the case in 1992 when Planned Parenthood of Pennsylvania, an abortion rights advocacy group, sued the state's governor, claiming that the state's Abortion Control Act violated the constitutional protections on abortion outlined in the Supreme Court's decision in Roe v. Wade. In particular, Planned Parenthood argued that the clauses in the state legislation that required a pregnant woman to notify her husband, a pregnant teen to get parental consent, and any abortion seeker to satisfy a 24-hour waiting period after receiving counseling presented an undue burden and violated the spirit of Roe v. Wade. In Roe, the Supreme Court had ruled that a woman's right to an abortion was essentially guaranteed in the first trimester, could be regulated by the states in the second, and could be banned by the states in the third. The Supreme Court agreed to hear the Planned Parenthood case and struck down some components of the Pennsylvania legislation, including the requirement for spousal notification, while allowing other components not specified in Roe, including the parental consent requirement and the 24-hour waiting period to stand. By litigating, interest groups can ensure that laws passed by legislatures and signed by executives are in keeping with current constitutional interpretation. By bringing their causes before the courts, they can also shape policy and encourage enforcement by executive agencies. Interest groups are one of the chief sources of information for policymakers. Interest groups have the resources to investigate the impact of policies. They have access to data, technological know-how, and a bevy of experts with extensive knowledge of the issues. Most interest groups provide information to policymakers, and policymakers understand that the information received is slanted toward the group's interests. But if competing interest groups supply information to policymakers, then policymakers can weigh the merits of the various sets of information. Sometimes interest groups use celebrities as experts to testify, knowing that they will attract greater attention than most policy experts. Elmo, the furry red Sesame Street Muppet, testified in 2002 on behalf of a bill that would provide $2 million in federal funding to public schools for music education. The House Appropriations Subcommittee on Labor, Health, and Human Services and Education heard testimony from Elmo, who apparently is an authority on music education. Elmo told the subcommittee, Elmo loves to sing and to dance and to make music with all his friends on Sesame Street. It helps Elmo learn ABCs and makes it easier for Elmo to remember things. Sometimes it makes Elmo excited and sometimes it makes Elmo down. Elmo's teacher really likes that. My friend, American Music Conference Executive Director Joe Lamond, says some kids don't have music in school. That makes Elmo sad. Other celebrities who have testified on behalf of causes important to them include Bono, the lead singer of the group U2, who testified concerning debt relief for African nations, actor Michael J. Fox, who testified about Parkinson's disease from which he suffers, actor Goldie Hawn, who testified against granting permanent, normal trade status to China, and actor Julia Roberts, who spoke on behalf of those who suffer from Rett syndrome, a nervous system disorder disproportionately suffered by women.